This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about annoying discovery disputes and why discovery and suits against insurers are often aggressive, expensive, and not necessarily useful. The United States District Court conducted a discovery conference with the parties concerning their discovery disputes. The discovery rules of the federal government are accorded a broad and liberal treatment to achieve their purpose of adequately informing litigants in civil trials. At some point, discovery yields diminishing returns, needlessly increases expenses, and delays the resolution of the parties' dispute. Finding a just and appropriate balance in the discovery process is one of the key responsibilities of a trial court. In Kwame Moore v. Western World Insurance Company, the United States District Court for the Southern District of Mississippi on July 12, 2024, dealt with the discovery disputes between the parties who could not resolve their differences without assistance of the court. Federal Rule of Civil Procedure 26b1 provides that, quote, parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering the importance of the issues at stake in the action, the amount of controversy, the party's relative access to relevant information, the party's resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefits, close quote. According to the defendant, Western World, plaintiff has failed to produce emails, text messages, and other documents which Western World knows were sent to plaintiff. As an example, defendant stated that in response to a subpoena, Tom Weems, a third party who provided a report to plaintiff indicating that hail caused damage to plaintiff's building, produced text messages between he and plaintiff which have not been produced by plaintiffs in response to requests for such information. Plaintiff, through his counsel, asserts that he has conducted a search of his files and has no other documents to produce and cannot produce documents he does not have. Ordinarily, the representation of a party's attorney that no additional documents exist is sufficient to defeat a motion to compel, absent credible evidence that the representation is inaccurate. Lawyers are believed to not lie to their judge. At this time, the record does not establish that plaintiff did or did not conduct a reasonable search. Plaintiff does not explain what efforts he made to find and produce responsive information or why responsive information he once possessed is no longer in his possession. Defendant has also not made this showing. Thus, defendant has not demonstrated that plaintiff is unlawfully withholding responsive information despite plaintiff's representations. Without more, counsel's representation that plaintiff does not possess responsive information is sufficient to defeat the motion to compel. The denial of the motion to compel, however, was issued without prejudice to defendant's right to reassert it if defendant can show plaintiff possesses the information, failed to conduct a reasonable search, wrongfully disposed of the information, or otherwise violated his duties in discovery. Defendant also requested that the court compel a forensic examination of plaintiff's computers, cell phones, and mail servers. The court found that this request was premature. If plaintiff no longer possesses this information, the court cannot determine whether a forensic examination is warranted. Thus, the request was denied. however, without prejudice. The court also noted that the plaintiff also argued that he should not be required to produce duplicative documents which are already in Western world's possession. However, it is not a bar to the discovery of relevant material that the same material may be in the possession of the requesting party or obtainable from another source. The plaintiff makes this objection is kind of curious given the plaintiff's representation that he has no such information, duplicative or otherwise. To the extent plaintiff is withholding responsive information based on this or any other objection, the court grants the motion to compel, and therefore, on or before July 22, 2024, plaintiff shall produce any responsive information previously withheld based on this objection, or inform defendant in writing that he is not withholding information based on this objection. In my opinion, before I retired from the active practice of law, or the practice of law at all, I was an active insurance litigator and dealt with multiple annoying and overbroad discovery disputes designed to cost the insurer rather than obtain information that would assist in the trial of the matter. In this case, it's the insurer who's imposing discovery upon the plaintiff, but the bludgeon of discovery becomes a weapon used to force a settlement unfavorable to one or the other party because of excessive attorney's fees and costs. The court, in its orders, including its orders without prejudice, was an attempt to calm the excesses between the parties. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to more than 4,800 blog postings. You can also subscribe to the videos on YouTube and on rumble.com. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. If you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.